If understanding your rights clearly, instead of just vaguely, is something that matters to you, I'd really appreciate it if you hit subscribe before you go, because that's exactly what this channel is built around, one real, specific legal topic at a time, explained in plain language without the unnecessary complexity. It genuinely helps more than you'd think, mostly because it tells me this kind of plain language legal content is actually reaching the people who need it, which is the entire point of doing this in the first place. All right, that's the ask. Let's keep going. It happens fast. One moment you're driving, music on, maybe a little tired, maybe running through a mental list of everything still left in your night, and then you see it in the rearview mirror, the lights. Blue and red, sometimes white, cycling through the dark behind you, and in that exact second, before you've even started to slow down, before you've even signaled toward the shoulder, something happens in your chest that no amount of calm preparation fully prevents. Your heart rate picks up, your hands grip the wheel a little tighter, and somewhere in the background of your mind, a scrambled series of questions starts competing for space all at once. What did I do? What do I say? What do I touch? What do I not touch? And most of all, what happens next? Here's what I want you to know before anything else. That reaction is completely normal, and it doesn't mean anything about how this encounter is going to go. But what you do in the minutes immediately following those lights appearing in your mirror, and I mean the very specific sequence of decisions you make before the officer even reaches your window, can determine more about how this stops goes than almost any other factor, including whatever reason you might have been pulled over in the first place. So before we go any further, if you want to actually understand your rights in these moments, not just have a vague sense of them, not just guess at them when it actually matters, hit subscribe right now, because this is exactly the kind of content this channel is built to give you, scenario by scenario, in enough detail that it actually sticks. Quick note before we start, this is legal education and commentary, not legal advice for your specific situation, and some details shift state to state, but the core principles we're going to walk through hold up almost everywhere in this country. Let's get into it. Let's start with the thing that almost nobody tells you clearly, and it's this. Being pulled over at night is legally and practically different from being pulled over in broad daylight, and understanding exactly how it's different changes the entire framework of what you should and shouldn't do. The darkness matters, not just practically in terms of visibility, but in terms of how courts have interpreted the dynamics of nighttime stops, how officers are trained to approach them, and what risks on both sides of the window are genuinely different after dark compared to a sun-drenched afternoon on a busy road. Officers pulling someone over at night are aware that they have less ability to see inside the vehicle, less ability to assess the situation before reaching the window, and a set of concerns that differ from a midday traffic stop in ways that affect everything from the pace of the interaction to the questions they're likely to ask. Understanding that context doesn't mean you have to agree with how those concerns get applied to you specifically, but it does mean you can interact more effectively, more calmly, and more strategically when you understand what the officer approaching your car is likely already thinking as they walk toward your window. The very first thing that happens after those lights come on is that you need to pull over, and how you pull over actually matters more than most people realize. You're looking for the safest, most well-lit location you can reasonably reach quickly, a gas station parking lot, a well-lit side street, a strip mall shoulder. Not because you're required to find perfect conditions, but because courts have consistently recognized that a driver has a reasonable amount of time to find a safe place to stop, and using that time to find somewhere with better lighting is not only legally fine. It's interesting, honestly, how often variations of this general subject keep coming up, across completely different specific situations, over and over. I think that's because the underlying pattern is more universal than people initially assume. A moment of pressure, a question that sounds simple but carries real legal weight, an instinct to just go along with things smoothly rather than pause and think it through. That basic shape shows up across an enormous range of otherwise completely different situations, which is exactly why understanding the underlying pattern, rather than just memorizing one specific scenario, ends up being so useful. Once you see the shape clearly in one context, you start recognizing it everywhere else too. All right, let's dig into today's specific version of that pattern. It's actually smart for your protection and for the officers. A stop that happens in a well-lit area is a stop that's documented better, seen more clearly by any cameras in the area, and generally safer to conduct than one on the side of a dark, narrow road where visibility is essentially zero. If you're driving for more than a few seconds before stopping, turn on your hazard lights to signal that you're aware of the officer behind you and are actively looking for a safe spot. This communicates clearly that you're not attempting to flee, which matters, because hesitation in pulling over after dark can sometimes be interpreted more suspiciously than the same hesitation would be in daylight. Pull to the right, signal your turn, slow down steadily, and get to the shoulder safely. That's step one, and doing it calmly and deliberately is already telling a story about this stop that works in your favor. Once you've stopped, you're going to want to do something that feels almost counterintuitive given the urgency of the moment, and that's this. Before the officer reaches your window, do not reach for anything. Not your glove compartment, not your center console, not your insurance card tucked behind the visor, not your wallet, not your phone, nothing. Put your car in park, turn off the engine, and if it's genuinely dark, meaning the interior of your car is difficult to see into, turn on your interior dome light. That last point is something most people have never thought about, and it's one of the single most effective things you can do in those first moments to set the tone of the entire encounter, because it communicates immediately and without a single word that you're not hiding anything, that you're making yourself and your hands visible, that you understand this interaction is happening and you're meeting it openly. It also functionally removes one of the primary concerns driving officer behavior during nighttime stops, the inability to see what's happening inside the vehicle, and when that concern is reduced, the entire temperature of the interaction tends to come down with it. Hands on the wheel, both of them, visible, not in your lap, not resting on the door, but actually on the wheel, where they can be seen clearly from outside the car. This is not a submission. This is a communication, and it's a communication that experienced attorneys, former law enforcement professionals, and civil rights advocates all tend to agree on, because it removes ambiguity at the exact moment when ambiguity is most likely to cause a problem. An officer approaching a car in the dark is assessing that situation constantly, reading every available signal about what kind of encounter this is going to be, and hands on the wheel is one of the clearest, most unambiguous signals available that the person inside is cooperative, calm, and not a threat. That assessment, made in the first few seconds before anyone has said anything, shapes everything else that follows. Window down, not cracked slightly, not halfway, all the way down, or at least far enough that communication is completely clear and unobstructed. Some people in some states have asked whether they're legally required to roll the window all the way down, and the honest answer is that it varies somewhat, but the more important question is what actually serves you best in this moment. And the answer to that is clear and unambiguous communication from the very first second. Not a conversation conducted through a sliver of open window that introduces friction before anything meaningful has even been said. Roll it down, take a breath, wait. And now here's the part that most people get completely wrong. And I don't mean wrong in the sense of making a deliberate mistake. I mean wrong in the sense of acting on pure instinct without understanding what that instinct is about to cost them. The moment the officer reaches your window, the almost universal instinct is to immediately start reaching. Reaching for your license, reaching for the glove compartment, reaching for the registration, before anyone has said a single word, because we've been conditioned since driver's ed to think that reaching for those documents immediately is what cooperative, compliant drivers do. But here's what that instinct doesn't account for. An officer who has just walked up to a dark vehicle at night and suddenly sees the driver's hands disappear toward a glove compartment or a center console or somewhere out of view is experiencing something specific in that moment, and it's not reassurance. Even if you know, with complete certainty, that you're reaching for your insurance card, that officer doesn't know that yet. And the split-second interpretation of that movement happens faster than any explanation you might offer. The rule is simple, and it's worth memorizing exactly. You do not reach for anything until the officer has spoken to you, identified the reason for the stop, and specifically asked you for your documents. That's the moment, when the officer says, "Can I see your license and registration?" that you reach for them, and when you do, you say exactly what you're reaching for before your hands move to get it. "My license is in my back pocket. Is it okay if I reach for it?" Or, "My registration is in the glove compartment. I'm going to open it now," are sentences that sound almost unnecessarily formal in the abstract, but are genuinely important in the specific context of a nighttime stop, because they narrate your movements in real time, eliminating ambiguity completely. You know exactly what you're doing. The officer needs to know too, and these sentences make sure they do. Let's talk about those first few seconds of actual conversation, because the words you choose here and the tone you use set the foundation for everything else. The officer is going to say something like, "License and registration, please," or "Do you know why I pulled you over?" And how you respond to each of these matters in ways that are worth thinking through carefully in advance, not improvising under pressure in the dark on the side of a road. Do you know why I pulled you over? This question sounds simple, conversational almost, and it feels like the natural, cooperative thing to do is to answer it honestly and directly. But here's what that question actually is, from a legal standpoint. It's an invitation to provide information that might be self-incriminating, before you've been formally told what the officer believes the violation is, and before you've had any opportunity to assess the situation. If you say, "I think I was going a little fast," and it turns out the officer stopped you for a broken taillight, you've just provided evidence of a traffic violation that wasn't even the stated reason for the stop. The answer to, "Do you know why I pulled you over?" that serves your interests best, is honest, simple, and doesn't offer anything beyond what the question strictly requires. "I'm not sure. Could you tell me?" That's a complete answer. It's not evasive, it's not combative, and it gives the officer the opportunity to tell you exactly what they believe the issue is, without you having contributed any additional information that you didn't need to contribute. Here's a principle worth understanding at a deep level, because it runs underneath every specific rule in this entire video. Information you don't give cannot be used against you later. That's not the same as lying. Lying is something different entirely, and lying to a law enforcement officer can carry its own legal consequences in most states. The distinction is between lying and simply not volunteering. You're not required to narrate your evening, explain where you've been, explain where you're going, or provide any account of your activities beyond your identity in a stop where that's legally required. "I'd rather not answer additional questions" is something you're allowed to say, calmly, as many times as it needs to be said. Let's talk about the documents themselves, because there's a practical layer here that's worth walking through carefully. In almost every state, you are legally required to provide your driver's license, vehicle registration, and proof of insurance upon request during a lawful traffic stop. These aren't optional. Refusing to provide them is generally not a legally protected decision, the way that, say, declining to answer questions about where you've been is protected, and in many states, refusal to provide identification during a lawful stop can itself be treated as a violation. So produce the documents when asked. What you're preserving, what all of these other principles are protecting, is everything beyond those documents, everything that isn't a legal requirement, but that an officer might hope to gain from the interaction through the space your cooperation opens up. Here's where a lot of people encounter a fork in the road and go the wrong direction without even realizing it. The moment after they've handed over their license and registration, many people feel that the hard part is over, that the interaction has shifted into a different gear, that the pressure has reduced. And in that moment of reduced alertness, questions start coming. Casual ones, conversational ones, the kind that don't feel like legal questions at all, and people answer them. And the answers become part of the record of this stop, in ways that can matter later. "Have you been drinking tonight? Where are you coming from? Is there anything in your car I should know about?" These questions can feel like small talk, like the officer is just trying to get a read on you, and in some cases, that's genuinely all they are. But they can also be the beginning of the evidentiary foundation for a much larger investigation, and you don't have to contribute to that foundation by answering them. "I'd rather not answer additional questions," said calmly, without hostility, is your complete right, and exercising it doesn't make you guilty of anything. It makes you someone who understands the difference between legal requirements and voluntary cooperation. Let's talk about search requests specifically, because this is really where the most significant legal territory in a traffic stop lives, and it's where the clearest, firmest responses matter most. If an officer asks whether they can search your vehicle, understand what's actually happening in that moment. They're asking because they don't already have the legal right to search it without asking. If they had probable cause to search, meaning specific, articulable facts that would lead a reasonable officer to believe evidence of a crime is present, they generally don't need to ask for consent at all. When the request comes, it means this is a voluntary, consensual encounter, and your answer shapes everything about what happens next. The answer, unless your attorney has told you otherwise and circumstances are unusual, is no. Said politely, firmly, completely. "I don't consent to a search of my vehicle." Not "I'd rather you didn't," which sounds like a preference they can work around. But "I don't consent," which is a legal statement establishing clearly that any search that follows happened without your agreement. You don't have to explain why. You don't have to justify it. You don't have to say anything beyond that sentence. "I don't consent to a search of my vehicle," said once, clearly is enough. And if you have to say it more than once because the request keeps coming in different forms, you say it again, just as calmly, just as clearly, as many times as necessary. Why does it matter? Because evidence obtained through a search you consented to is almost always admissible in court, regardless of how that consent was obtained, or whether you fully understood your right to refuse it. Evidence obtained through a search conducted over your objection without legal justification is much more likely to be challengeable later, and whether it's ultimately suppressed is a question for a judge examining the specific circumstances, not a question that gets resolved at the side of the road on the night of the stop itself. Your refusal doesn't end the encounter or guarantee anything about the outcome, but it creates a legal record that a warrantless search happened without your consent, and that record has value that doesn't exist if you said yes. Let's talk about what happens if the officer says they're going to search anyway, or calls for a drug dog, or says they're detaining you while they get a warrant. Because this is the part of the encounter where the instinct to comply physically, to resist physically, to argue verbally, or to try to change the officer's mind through explanation all feel urgent, and none of them are actually the right move. If an officer announces they're searching your vehicle, you state clearly, one more time, "I don't consent to this search." And then you do not physically interfere. Not because you're giving up, not because you've decided this is fine, but because the fight over whether this search was legal does not happen on the side of the road at night. It happens later, in a courtroom, with your attorney, with the benefit of time and documentation, and a neutral fact finder who isn't standing in the dark next to your car. Physical resistance to a search you believe is illegal changes the nature of what's happening. It introduces risks, it introduces charges, and it removes the clean legal question of "was this search lawful?" from the picture entirely, replacing it with a much messier situation that serves you significantly less well. This is hard to accept in the moment because it feels like acquiescence, but there's a profound difference between acquiescing to a search, saying yes, waving them in, cooperating fully, and simply not physically blocking a search you've already clearly stated you don't consent to. The statement is what matters legally. The statement is what gets preserved. The statement is what your attorney uses later. And "I stated clearly that I didn't consent and I didn't physically interfere" is a much better legal starting position than any alternative. Let's talk about drug-sniffing dogs specifically, because this comes up constantly in nighttime traffic stop discussions and causes a tremendous amount of confusion. The Supreme Court in Illinois v. Cabales established that an officer can use a drug-sniffing dog on the exterior of your vehicle during a lawful traffic stop, without that itself constituting a Fourth Amendment search, provided that the stop isn't prolonged beyond its lawful duration specifically to allow for the dog sniff. That last part, the prolonging, is where the more recent legal development lives, because Rodriguez v. United States in 2015 clarified that even a brief extension of a stop beyond the time reasonably necessary to complete the traffic mission is a constitutional violation if there's no independent reasonable suspicion justifying the extension. This means that if an officer completes the purpose of your stop, runs your license, issues the ticket or warning, and then asks you to wait while a dog is brought to the scene, that extended detention may itself be a Fourth Amendment issue, and it's one worth raising with an attorney after the fact if it happens to you. What you do in the moment when a dog is being walked around your car is the same as everything else. State that you don't consent, don't physically interfere, keep your hands visible, and document everything you can remember afterward. The legal question of whether the sniff was lawful, whether any alert it produced justified the subsequent search, and whether the stop was unconstitutionally extended to allow it, those questions all get answered later, not now. Let's talk about the specific scenario of being asked to step out of the vehicle, because Pennsylvania v. Mims established that officers can ask drivers to exit their vehicles during a lawful traffic stop without that exit itself constituting an unreasonable seizure. You comply with this request. You step out calmly, carefully, without sudden movements, and you continue to communicate your movements before you make them. "I'm going to put my hand on the door frame as I get out," and you keep your hands visible throughout. Complying with a request to exit the vehicle is not the same as consenting to anything else that might follow, and your prior statements about not consenting to a search apply equally to your person and your belongings once you're outside the vehicle. If you're asked to stand at the rear of your vehicle while the officer conducts some activity at the front, or asked to wait on the curb, you comply calmly. You're observing everything. You're noting what you can in terms of what officers are saying, what they're doing, what time it is, what the conditions are. You're not narrating this observation out loud in a way that sounds confrontational. You're simply paying attention, because your memory of what happened during this stop is going to matter if this stop becomes significant later. Let's talk about passengers in the vehicle, because their situation is worth understanding separately from the drivers, and the intersection of rights between driver and passenger during a nighttime stop is something worth thinking through before you're ever actually in that situation. Passengers in a vehicle that's been pulled over are also seized under the Fourth Amendment for the duration of the stop. They don't have the freedom to simply open the door and walk away just because the stop is technically for something related to the driver. But passengers also have their own rights, including the right to decline to answer questions and the right to decline to consent to a search of their personal belongings. If an officer asks a passenger where they're going or where they've been, the passenger has the same right to decline to answer as the driver does. If an officer asks whether they can search a bag that belongs to a passenger, that passenger can decline consent to that specific search. The driver's consent to a vehicle search doesn't automatically extend to items clearly identified as belonging to a passenger, though the specifics here vary by jurisdiction and the exact circumstances of how items are stored. It's worth having a brief, calm conversation with anyone you regularly drive with about what these situations look like and what the basic principles are. For exactly the same reason, it's worth having that conversation with anyone who might answer your front door in your absence. Because the person in the moment, operating on pure instinct, doesn't always make the same decisions they would make with a few minutes of calm reflection in advance. Let's talk about what to do if you believe the stop itself was unlawful. If you genuinely don't believe you did anything that justified being pulled over, or if something about the way the stop was initiated seems improper to you. This is a real concern worth taking seriously, and there are legitimate legal avenues for challenging an unlawful stop after the fact. But the roadside, in the dark, with an officer standing at your window, is not the forum for that challenge. "You didn't have a reason to pull me over" is something you can absolutely tell your attorney, who can file a motion to suppress any evidence obtained during an unlawfully initiated stop. And if that motion is successful, the consequences can be significant for the prosecution's case. What it is, not something you should try to litigate at the window during the stop itself, because that conversation serves nobody's interests in the moment and often makes the situation functionally worse without improving the underlying legal position at all. The stop happened. You're in it. The question of whether it should have happened is for later, and later is where that question gets answered properly. Let's talk about recording this interaction, because this is one of the most frequently asked questions in contexts like this one, and the answer is more nuanced than most people expect. In most states, you have the legal right to record your interactions with law enforcement in public or semi-public settings, including during a traffic stop, provided that doing so doesn't interfere with the officer's ability to conduct the stop. That's a legally recognized right in the vast majority of jurisdictions, grounded in the First Amendment. But here's the practical layer that matters just as much as the legal one. How you record it matters enormously. Reaching suddenly for your phone in the middle of a nighttime stop, particularly before the officer has reached your window or during a tense moment in the conversation, introduces exactly the kind of ambiguity you've spent the entire beginning of this encounter trying to eliminate. If you're going to record, the better approach for nighttime stops is a dash cam that runs continuously, a tool that captures everything automatically without requiring any movement on your part at any point during the stop. If you have a dash cam, it's already doing what it needs to do. If you don't, the secondhand documentation option, phone recording, is something to approach carefully, announced verbally if possible. "I'd like to let you know that I'm recording this interaction." This serves the dual purpose of creating the legal record you want and communicating your intentions clearly, so that the act of recording doesn't itself introduce a new layer of tension to an already charged situation. Let's talk about what happens after the encounter, whether it ends with a ticket, a warning, or something more serious. Because the minutes immediately following a stop are ones most people treat as relief time, a period to decompress and process what just happened. when they actually function more like a window for documentation that closes fast if you don't use it deliberately. Pull into the first well-lit, safe location you reach after leaving the stop and take 5 minutes to record everything you can remember, either in a voice memo or written notes. Not your interpretation of it. The facts. What time was it? What road were you on? How long did the stop last? How many officers were present? Were there other vehicles, witnesses, other patrol cars? What exactly was said, as close to verbatim as you can reconstruct it? What did you consent to or decline? Whether any search occurred and exactly what was searched? Whether anything was taken or photographed? Whether a drug dog was present, and if so, what happened? This documentation exists for a reason that has nothing to do with assuming the worst about what happened. It exists because if this stop becomes relevant to anything that follows, whether that's a court appearance, a civil rights complaint, a conversation with an attorney about the lawfulness of what happened, or simply your own clear memory of an event that felt significant at the time, contemporaneous notes are worth dramatically more than recollections assembled weeks later. Memory is reconstructive, and reconstruction is unreliable in ways we consistently underestimate about ourselves. 5 minutes now is worth more than an hour later when the details have softened and blurred together. Let's talk about something that almost every discussion of traffic stop rights glosses over entirely, and that's the emotional reality of what you're actually managing in these moments, and why it makes everything harder than it sounds on paper. Reading through a list of rights in calm conditions and actually exercising them on the side of a dark road with lights cycling behind you, an officer with a flashlight at your window, and your hands trembling slightly on the steering wheel, these are not the same experience. The knowledge doesn't automatically become behavior, without some space between reading it and needing it, and the gap between knowing your rights abstractly and actually using them confidently under pressure is where most people find themselves when it counts. This is the real reason preparation matters more than any specific rule. Because what preparation does isn't give you a script to recite mechanically. It gives you a framework that lives in your body, something you've thought through enough times and in enough detail that when the moment arrives and the adrenaline is present and the instincts are pulling in different directions, you don't have to decide from scratch. You've already decided. You're simply recalling and executing a decision that was made from a much calmer, much clearer version of yourself, one that had time to think carefully about what actually matters and why. That calm version of you is the one that gets to speak here tonight. The one that remembers the interior light, remembers the hands on the wheel, remembers I don't consent to a search of my vehicle, remembers not to reach for anything until the officer has spoken and specifically asked, remembers to narrate every movement before making it. And the one that knows, clearly and without doubt, that none of this, not a single word of it, is about having something to hide. It's about understanding the difference between what law requires of you and what encounters are designed, through habit and social pressure and the sheer weight of authority, to make you feel is required. Let's talk about one more specific scenario that deserves its own careful treatment, and that's what happens when you're pulled over at night and something about the stop feels wrong from the very beginning. Not legally complex wrong, but instinctively wrong. The kind of feeling that's harder to articulate but worth taking seriously. Maybe you're on a very isolated road. Maybe you're not sure whether the lights behind you are actually law enforcement or someone pretending to be. This is not paranoia. It's a legitimate concern that law enforcement agencies themselves have addressed through official guidance. And the answer is something worth knowing. You are not required to immediately stop on an isolated dark road if you have genuine, reasonable concerns about the legitimacy of the lights behind you. What you do is turn on your hazard lights immediately, reduce your speed to signal that you're aware of the vehicle behind you, and drive at a reduced speed to a more populated, well-lit area, a gas station, a commercial area, somewhere with people and lights and cameras, before pulling over. In many jurisdictions, calling 911 while doing this is explicitly endorsed by law enforcement agencies, both because it creates a record of your actions and your stated concerns, and because if the vehicle behind you is a legitimate officer, dispatch can confirm that and communicate it to both parties. I can see lights behind me, and I believe it may be an officer. I want to confirm this is legitimate before I stop, because I'm on an isolated road, is a sentence you can say to a 911 dispatcher, and it is exactly the kind of precautionary communication that has been explicitly validated. A legitimate officer will understand this. A legitimate officer who does not understand it and becomes hostile about a driver's reasonable concern about stopping safely is an officer whose conduct during the stop that follows deserves particularly careful documentation afterward. Let's walk through the exact words for the most common versions of a nighttime traffic stop conversation, because just like we did with the front door scenarios, I want you leaving with specific sentences that live in your memory as ready responses, not principles you have to translate into words under pressure. When the officer reaches your window and greets you, or tells you why they pulled you over, you respond calmly, make eye contact, and say "Thank you, officer," or simply acknowledge what they've said, without adding anything beyond that acknowledgement. When they ask, "Do you know why I pulled you over?" "I'm not sure. Can you tell me?" When they ask for your license and registration, "Of course. My license is in my wallet in my back pocket. Is it okay if I reach for it and wait for confirmation before moving?" "Then my registration and insurance are in the glove compartment. I'm going to open that now." When they ask where you're coming from or where you're headed, I'd rather not answer additional questions, but I want to be cooperative with the stop itself. When they ask whether you've been drinking or whether there's anything in the car, I'd prefer not to answer questions beyond what's required for the stop. When they ask whether they can search your vehicle, I don't consent to a search of my vehicle. When they say they're going to search anyway, or that they're going to get a dog, I understand, and I want to be clear that I don't consent to this search, and then you don't physically interfere. When they ask you to step out of the vehicle, you comply. Calmly, slowly, hands visible, narrating your movements. "I'm getting out now. I'm going to put my hand on the door frame." When the stop is concluding and they return your documents, "Thank you," and nothing more. That isn't strictly necessary. Every single one of those sentences is polite. Every single one of them is complete. Every single one of them establishes something important on the record, without offering anything that doesn't need to be offered, and every single one can be delivered in a warm, calm, even apologetic tone, without losing a single ounce of its legal effect. The warmth costs you nothing. The firmness protects everything. Let's talk about something that deserves a direct, honest conversation. The reality that not every traffic stop unfolds the same way for every person, and that the dynamics of a nighttime stop can vary based on factors that have nothing to do with what you did or didn't do behind the wheel. If you're someone for whom that reality is not an abstraction but a lived experience, the framework we've been discussing throughout this video carries even more weight, not because it changes the underlying legal principles, which apply equally regardless of who's in the car, but because every tool available to you for documenting the stop, for creating a clear and contemporaneous record of exactly what happened and exactly what was said, for stating clearly and on the record what you did and didn't consent to, becomes even more valuable as evidence of the encounter that actually occurred, rather than the one that might later be reconstructed differently. The dashcam running, the calm and clear communication of your lack of consent, the hands visible, the movements narrated, the detailed notes written immediately after. All of these serve a function that goes beyond simply being cooperative, and understanding that function is worth being clear-eyed about. Let's talk about what it means when a stop escalates beyond where any of us expect it to go, when you're told you're being placed under arrest, or when handcuffs come out, or when what started as a routine traffic matter has shifted into something categorically different. This is the scenario people most want a script for, and the one where the script matters least, because the specifics are so varied that no general preparation can anticipate all of them. But there are principles that hold regardless. You continue to not physically resist. You continue to state clearly, "I don't consent to this," as often as is relevant. You continue to observe and remember everything you can, and the moment you have any opportunity to speak with an attorney, you take it and you do not answer any further questions until you have. "I am invoking my right to remain silent, and I'd like to speak with an attorney," is a sentence worth knowing by heart. Not because you expect to need it, not because saying it means you've done something wrong, but because it is the single clearest, most legally protective sentence available to you the moment an encounter has shifted into territory that might result in charges. And being able to say it calmly and clearly in a high-pressure moment requires having thought about it enough times in calm moments that it's genuinely instinct by now. Let's talk about one more scenario that gets surprisingly little attention in these discussions, and that's what happens when you're the passenger in a vehicle that gets pulled over at night, when this entire encounter is happening around you, but the driver is the one at the wheel, making the decisions, and you're sitting there trying to figure out what your role is and what your rights are in a situation you didn't initiate and may not be able to influence. The core answer is your rights as a passenger are substantially the same as the driver's when it comes to answering questions and consenting to searches of your person or your belongings. You're seized for the duration of the stop the same way the driver is, meaning you're not free to simply get out and walk away, but you're also not required to answer questions about where you're going, what your relationship to the driver is, or anything else that isn't legally required. If an officer addresses you directly, asking questions, you can say exactly what the driver can say. I'd prefer not to answer additional questions. If they ask to search a bag that's clearly yours, you can say, I don't consent to a search of my belongings. You don't need the driver's permission to assert your own rights, and the driver's choices about their own level of cooperation don't obligate you to any parallel level of cooperation you haven't chosen for yourself. Let's take a step back for a moment, because I want to address something that runs underneath this entire conversation and that I think is worth naming explicitly, because it's the thing that makes people most resistant to actually using any of this information when they need it. There's a widespread belief, almost a cultural instinct, that asserting your rights during a police encounter, asking whether there's a warrant, declining to answer questions, refusing a search, is something that only guilty people do. That only someone with something to hide would say, I don't consent to a search. That cooperating completely, saying yes to everything, answering everything openly, is the marker of an innocent person, and that refusal is the marker of someone with a secret. This belief is wrong, and it's worth being direct about that, because it's the single most powerful thing keeping genuinely innocent people from using protections that belong to them. Courts have explicitly repeatedly recognized that the exercise of constitutional rights is not evidence of guilt. Refusing consent to a search establishes nothing about whether there's anything to find. Declining to answer questions is not an admission of anything. The Fifth Amendment right to remain silent and the Fourth Amendment right to be free from unreasonable searches and seizures exist regardless of guilt or innocence, and they exist specifically to be used, not to be held in reserve for some hypothetical moment of obvious necessity that never feels clear enough in the actual moment to justify using them. The reality is that evidence suppression, wrongful charges, and situations that started as minor traffic stops and became something much more serious happen to innocent people with significant regularity, and they happen more often to people who cooperated fully, who said yes, who answered every question, who let the search happen because they thought that was what cooperating looked like. Understanding that cooperation and legal protection are not opposites, that you can be completely courteous, completely non-hostile, completely respectful, while also declining consent and declining to answer questions, is the shift in thinking that makes everything else in this video actually usable. You don't have to choose between being a good person and knowing your rights. You're allowed to be both, simultaneously, on the side of a dark road at 11 o'clock at night, with lights cycling behind you and an officer walking toward your window. The interior light is on, your hands are on the wheel. Your voice is calm, you know exactly what you're going to say and exactly what you're not going to say, and the reason you know it is that you took the time to actually think about it, not in the moment, not improvising under pressure, but here, now, in the calm before any of it is necessary. Let's bring everything together one final time, because I want this framework sitting clearly and completely in your mind, in a form simple enough to recall under genuine pressure. You see the lights. You find a safe, well-lit place to pull over. You signal your compliance with your hazard lights if you take a moment to get there. You park, engine off, interior dome light on, hazards off, hands on the wheel, window down. You wait for the officer to approach and speak first. You answer, I'm not sure, can you tell me? 2. Do you know why I pulled you over? You reach for documents only when asked, narrating every movement before you make it. You answer questions about your identity and produce required documents. You decline additional questions with, I'd prefer not to answer further questions. You decline any search with, I don't consent to a search of my vehicle, stated clearly, as many times as necessary. You don't physically interfere with anything you don't consent to. You comply with requests to exit the vehicle, calmly and slowly, hands visible. You stay calm throughout, warm in tone, firm in substance. And the moment the stop concludes, you go somewhere safe, and you document everything you can remember before that memory starts to fade. That's the framework. That's what the interior light means. That's what I don't consent to a search of my vehicle means. That's what narrating your movements means. Not guilt, not hostility, not an adversarial posture toward law enforcement. A calm, prepared, legally informed version of yourself who understands exactly what the law requires of you and exactly what it doesn't, and has decided in advance, from a position of clarity rather than pressure, how to handle the moments where the difference matters. The sentence worth memorizing tonight, right now, before you close this video, before you put your phone down or close the browser, is this: I don't consent to a search of my vehicle. Say it out loud. Say it in your normal voice, the voice you'd use if you were actually sitting in your car. Notice that it's not aggressive. Notice that it doesn't require any particular emotion or attitude. Notice that it's short enough to say clearly, even if your voice is slightly unsteady from adrenaline. That sentence, said clearly, once, is doing something that no amount of after-the-fact explanation can replicate. It's creating a record, in the moment, that what follows was not something you agreed to. The other sentence worth having ready is this: I am invoking my right to remain silent, and I'd like to speak with an attorney. That sentence, for the rare moment when a stop has shifted into something fundamentally different, is the clearest possible signal of where you stand and what happens next, and it protects everything that follows far more effectively than any answer to any question could. If what we walked through tonight filled in something you didn't have clearly in mind before, if this is the first time someone actually sat you down and walked through the nighttime traffic stop scenario in enough detail that it feels usable rather than theoretical, then you already know what to do next. Hit subscribe, because there's more of this coming, one scenario at a time, the kind of specific, detailed preparation that turns a charged, high-pressure moment into something you've already thought through, rather than something catching you completely unprepared. Stay calm, keep your hands visible, and remember that knowing the difference between what's required and what's voluntary is not about having something to hide. It's about having something worth protecting. Before I let you go, I want to say one more time that understanding your rights clearly isn't a small thing, even when the specific topic feels minor on the surface. It's the difference between navigating a real situation with confidence and navigating it with anxiety and guesswork. And that difference matters more than people usually realize until they're actually standing inside a moment where it counts. Thanks for spending this time building that understanding with me today. I'll see you in the next one.